Good morning. I am Parole Officer Renard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Calvin Nickerson, inmate number 418695. Today is Tuesday, May 19th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Calvin Nickerson, and my inmate number is 418695.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Nickerson.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of the fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by the preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction by the My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Nickerson, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon felony of perjury?
Yes, sir.
We're going to go over the procedure. You can put your hand down.
I'm sorry.
We're going to go over the procedure for the hearing now. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
All right, so we're going to go over your rights. You have the right to be represented by an attorney at this hearing, and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, sir.
You have the right to review the, that's all right. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, sir, I am.
We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge number one, reporting. You were instructed by this PO to report to the Hartford District Office on the following dates: February 2nd, 2026, February 3rd, 2026, and February 5th, 2026. You failed to report to this PO on February 2nd, 2026, February 3rd, 2026, and February 5th, 2026. You are in violation of your special parole condition number 1, release directions. On charge number 2, condition of GPS, on September 10th, 2025, you were instructed to submit to GPS monitoring and comply with your GPS monitoring agreement. You signed your GPS monitoring agreement on September 10th, 2025 with parole. On January 30th, 2026, January 31st, 2026, January 20th, 2026, January 19th, 2026, January 18th, 2026, January 17th, 2026, December 28th, 2025, December 27th, 2025, December 26th, 2025, and December 25th, 2025, and November 5th, 2025, and October 31st, 2025. You violated your GPS monitoring agreement number 11 that states, I will remain at my approved residence between the following hours, 9 p.m. to 6 a.m. You were in violation of your special parole condition number 1, release directions. On January 15th, 2026, and November 13th, 2025, you allowed your GPS monitoring device battery to shut down. You violated your GPS monitoring agreement number 4 that states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cables to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. You are in violation of your special parole condition number 1, release directions. On charge number 3, conditions of curfew, on September 10th, 2025, you're instructed to submit to GPS monitoring and comply with your GPS monitoring agreement. You signed your GPS monitoring agreement on September 10th, 2025 with parole. On January 30th, 2026, January 31st, 2026, January 20th, 2026, January 19th, 2026, January 18th, 2026, January 17th, 2026, December 28th, 2025, December 27th, 2025, December 26th, 2025, December 25th, 2025, November 5th, 2025, and October 31st, 2025. You violated your GPS monitoring agreement number 11 that states that I will remain at my approved residence between the following hours, 9 p.m. and 6 a.m. You were in violation of your special parole condition number 1, release directions. On charge number 4, condition of program participation, you missed your scheduled treatment appointment at CRT Behavioral Health Services in Hartford on January 9th, 2026 and February 2nd, 2026. You were a no-call, no-show. Your clinician at CRT Behavioral Health made attempts to contact you and reschedule you for February 17th, 2026. However, they were unable to make contact with you. You were discharged from the CRT Behavioral Health Services on February 18th, 2026 due to lack of attendance. On charge number 5, condition of absconder, you were instructed to report to the Hartford District Office on the following dates: February 2nd, 2026, February 3rd, 2026, and February 5th, 2026. You failed to report to this PO on February 2nd, 2026, February 3rd, 2026, and February 5th, 2026. You stopped charging your GPS, and your GPS has not been charged since February 1st, 2026. You last made contact with this PO on February 6, 2026. Your whereabouts in the community are unknown as of February 1st, 2026. You're in violation of your special parole condition number 1, release directions. On charge number 6, condition of drugs. On January 22nd, 2026, you rendered a urine that was sent to Premier Biotech Lab to test for all prohibited substances. Your urine results were returned from Premium Biotech on January 29th, 2026 with a positive results for cocaine substances. You are in violation of your special parole conditions. Obey all laws. On charge number 7, condition of no contact with victims. You were instructed by this PO to only have contact with your wife, Amber Stanton, by phone and through scheduled supervised DCF visits. This PO was advised by your DCF worker that you were being transported by your wife to your DCF visits. This PO did not approve this. You are in violation of your special parole additional condition, contact with victims. The state has filed the following exhibits that have been marked for identification purposes. Exhibit A, Connecticut conditions of special parole. Exhibit B, remand to actual custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, misconducts. Exhibit F, GPS monitoring agreement. Exhibit G, emails from CRT Behavioral Health. Exhibit H, Allied Universal GPS evidence. Exhibit I, Premier Biotech lab results. Exhibit J, drug paraphernalia found under Mr. Nickerson's mattress at 670-676 Broad Street in Hartford, his CRT DOC scattered site apartment. Exhibit K, text messages with Mr. Nickerson. Exhibit L, State of Connecticut Board of Pardons and Paroles Decision Information Summary. Exhibit M, State of Connecticut Board of Pardons and Paroles Revocation Hearing Summary. In addition, the state filed an addendum to the parole violation report that states, in reference to the parole violation report submitted by P.O. McClay regarding Calvin Nickerson, inmate number 418695, the following applies. On February 26, 2026, the Board of Parole issued a warrant for re-imprisonment based on that report. The case was subsequently transferred to the Fugitive Investigations Unit and assigned to P.O. Howlett on March 11, 2026. On March 31st, 2026, Nickerson self-surrendered at Hartford District Office. Nickerson was transported to Hartford Correctional Center, where a remand to custody order was lodged with A&D staff. Following the removal of wrist restraints, Nickerson was served with notice of parole violation. Parolee writes, a copy of remand to custody order, signed notice of parole violation, and parolee rights were uploaded to case notes that can be found in file attachment under parole violation evidence. A check of collect and NCIC and CT Judicial Web indicates no pending criminal and motor vehicle charges and no wants or warrants. Attorney Dean, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes, we have. Thank you.
The defense, and did you review this information?
Yes, we have.
The defense has filed the following exhibits, which are marked as follows. Exhibit 1, list of parole accomplishments and future plans for parole reinstatement, and Exhibit 2, lease addendum. Today, we have no witnesses. Attorney Dean, did you request any witnesses be allowed to testify at this hearing?
No, I did not.
It is now the defense's opportunity to call any witnesses, present evidence, and to speak to any of the evidence submitted.
Yes, thank you very much. This was a difficult situation my client was in. I believe that the majority of the current charges are due to him trying to prioritize getting his child back in his life and getting into compliance with DCF. He acknowledges he could have handled things better, but he did do the right thing by turning himself in. He is very eager to get home so that he can reunite with his family and continue moving forward on his parole. I will just note very briefly, as to charge 1 reporting, I would argue that there should be a partial no finding as to the 2/5 date. The text message dates that were on the text messages submitted couldn't really be discerned from the pictures that were submitted as to the 2/5 date. I will acknowledge that the prior ones were a little bit clearer. Just those last 2 pages were very blurry. And then charge 7, no contact with victims. I do just want to note My understanding is that the alleged victim in this case is my client's wife, who he has been with for approximately 20 years. They do share children in common, and my understanding is that she was initially my client's sponsor for about 3 to 4 years when he was initially put on parole, which was approved by parole prior to them being evicted from the place where they were living. From speaking with them both, I am now sorry, I would just note that, having spoken to them, my understanding is that they have at this point obtained long-term supportive housing. They have a lease, which we included as an exhibit, and their child, by my understanding, is now permitted to return to their care per their DCF case. I will note that my client's partner, from speaking with her, unequivocally wishes to have contact with him and has made it very clear that there are no safety concerns or anything of that nature. And the appropriate time, I would like to speak as well to his background and history. Thank you.
Thank you. And any closing statements before I announce my findings? Attorney team.
Nothing further. Thank you.
I will now take a moment to review the case and will notify you of my findings in a moment. I'm going to now announce my findings. For charge number 1, I find that you violated the condition of reporting based on the evidence presented in State's Exhibits A, D, and E. For charge number 2, GPS, I make a partial finding. I make a no finding on date December 25th, 2025 due to insufficient evidence. For the rest of the charge number 2, I find that you violate the condition of GPS based on the evidence presented in State's Exhibits A, D, E, H, and F. For charge number 3, curfew, I make a partial finding. I make a no finding on date December 25th, 2025 due to insufficient evidence. For the rest of charge number 3, I find that you violated the condition of curfew based on the evidence presented in exhibits A, D, E, H, and F. For charge number 4, I find that you violated conditions of program participation based on evidence presented in State's exhibits A, D, and G. For charge number 5, I find that you violated condition of absconder based on the evidence presented in exhibits A and D. For charge number 6, I find that you violated conditions of drugs based on the evidence presented in State's exhibits A, D, and I. For charge number 7, I find that you violated the condition of no contact with victims based on the evidence presented in exhibits A and D. That concludes the fact-finding portion of this hearing. Before I make my recommendation, the state will have the opportunity. State will have the opportunity to speak on your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Attorney Dean, do you wish to make a statement regarding the violation background history at this time?
Yes, thank you. My client is 47 years old, born in Philadelphia, raised in South Carolina. He's been in Connecticut for the past 10 years. He has a support system in the community, including his wife and his children. As we noted, there was DCF involvement concerning his youngest son, but my understanding is that my client's son has been going through the reunification process, both with himself and his wife. Most recently, upon release to special parole in July of last year, my client successfully completed Watkinson House and then was utilizing the CRT scattered site program in Hartford. Previously, he successfully completed Bishop House and was sponsored by his wife. Previously, while on supervision, my client started a barbering program through Branford Hall Institute. More recently, he returned to his full-time position at Road Construction Safety Services Flagging Company out of Burlington. He does have prior experience working for Big Y, RCSS, and JK Playgrounds. Most recent treatment includes methadone MAT treatment through Root Center in Hartford. He was also doing weekly individual therapy with CRT and was also doing the Bristol Recovery Club as well. My client, since being in the facility, has been doing MAT in the form of methadone, but he has been tapering off and his prescription has been going down each week. Upon reinstatement of parole, my client would like to be placed at a halfway house in Hartford, but his ultimate preference would be to return to living with his wife at the apartment that we had provided the lease for. He hopes to return to and complete a barbering program and is able to return to his full-time job flagging. He's very eager to reunite with his wife and their children and reobtain custody of their son through DCF. He's open to all treatment recommendations and is again very eager to return to his recovery group with Bristol Recovery Club. I am asking that you would consider releasing my client on the first available board review date. He has, by my records, never had any DRs while in custody in Connecticut. He does do very well, follows directions. He did turn himself in on this violation, which I think deserves some consideration. We also would ask that you consider not including the no contact provision with his wife based on the information provided. But in the event that that is in place, we are just hoping that his assigned parole officer will work with him so that he can in the future, completely reunite with his family. Sir, is there anything that I didn't include that you wish to say concerning your background or your future plans at this time?
My job is waiting for me, and I apologize for everything. I made a mistake, and I just want to be with my family, help raise my son. My son is back home now, and he really need my help. And I understand the wrongs that I've done. I really do. I just need to be with my family.
Thank you very much.
All right. Anything else you wish to say before I make my recommendation?
Nothing further. Thank
Oh, I'm sorry.
Oh, you're good. Did you have anything else that you wanted to say?
No, I just said thank y'all for taking the time out to go do this with me.
Thank you.
I've listened to the testimony and reviewed all the evidence provided. Based on that, I recommend that your special parole be revoked with a new re-parole date of July 29th, 2026. This is an approximate 4-month sanction. The sanction is calculated from the date you were remanded to custody. The following conditions are recommended for your special parole release. Halfway house placement, behavioral management with domestic violence, no contact with co-defendant Jimmy Lee Hoffick, Dustin Griffin, and Jordan Singleton, no contact with victim AS without PO's permission, and no operation of motor vehicle. My findings and recommendations will be forwarded to the board on May 28th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I've recommended. If the board decides to impose a sanction longer than what I've recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. This includes the revocation hearing. I am now going off the record.
Sir, if you have any questions, I can set up a legal call with you. And if you want to get a call to my office on the 28th, we can let you know what the board decides, okay?
Yes, ma'am.
All right, thank you very much. You're all set.
Thank you.
Hi, so, it may, Hotchkiss, what was the name? Hotchkiss, he said that he knows he's gonna get denied, so he doesn't want to come down here. I had the lieutenant go in there and talk to him, and he still says he's not coming down.
Okay. All right.
Okay?
Thank you.
All right, I'm gonna have, right.
We'll get started in just a minute, Mr. Riley.
Thank you.
Okay.
Mr. Riley, we're just gonna state something and we'll be right with you, okay?
Okay.
It's not regarding you, it's regarding another inmate, so just hold on, all right?
Okay.
We are on the record for inmate J. Hotchkiss, inmate number 283773. Inmate today is refusing to come down for a revocation hearing, and we're going to reschedule him. Attorney Dean.
Yes, I would respectfully request a continuance to June the 2nd. I unfortunately am out next week, but that week I will be back to handle the revocation hearing.
So we will see Mr. Hotchkiss on June 2nd, 2026.
Thank you very much.
And I'll see you.
You bet. Thank you.
Attorney Jones, you're all set? Sorry about that.
No, no problem. Thank you. Yes, I am.
Okay. Good morning. I am Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Patrick Riley, inmate number 241142. Today is Tuesday, May 19th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborne Correctional Institution. Please state your full name and DOC number for the record.
Patrick Riley, 241142.
This is a public hearing. Public access to this hearing is available via via video live stream. Present this morning is Attorney Jones. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Riley.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. One, to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. Two, to determine if the act is sufficiently serious to warrant the revocation of your parole. And three, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred by the Department of Corrections for a diversion for substance abuse programming and treatment. If by the end of this hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process, which is the TOP program. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Riley, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
I'm going to go over the procedure for this hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have the opportunity to address the issue of probable cause and the severity of the allegations if you choose. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, sir.
Okay. You have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney at this hearing. Your attorney is present. You have the right to receive written notice of charges of your violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, sir.
We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge.
If I may, my client is waiving the first portion of the hearing. I would ask to go to the eligibility section for the TOP program. Thank you.
Okay.
Thank you.
Okay. I accept the waiver and find that the acts are serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation hearing. I will now discuss TOP diversion eligibility. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means that if you wish to participate and apply and find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in a correctional facility. This is known as TOP. If you successfully complete the programs and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programs and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you wish to apply for diversion?
Yes and yes.
Okay. I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. Do you have anything else to add at this time?
I just appreciate the opportunity to go through the program and continue on with the opportunities that parole has given me so far.
I've reviewed all the relevant information and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the day of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with terms and conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. Okay, I have determined that you are eligible for a diversion for the substance abuse programming and treatment. Before I accept your application for a diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment, that parole revocation proceedings may be delayed as a result.
Yes, I understand.
Okay. I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse program and treatment.
I understand.
I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes, I understand.
I understand that my participation in this process is completely voluntary.
Yes.
Your application for a diversion is granted. You will be placed in treatment or programming by the Department of Corrections and diverted from revocation for no more than 60 business days. Good luck. This concludes the preliminary hearing, and I'm now going off the record.
Thank you so
Good
much.
luck, Patrick.
Thank you.
Good luck. You're welcome. Thank you.
Thank you.
Yes.
I will review and make.
No, sir.
I will review and make findings.
He's in here, he's seated.
Thank you. We'll start momentarily. Thank you. Good morning. I am Parole Officer Menard, the hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Marquise Hernandez, inmate number 432-663. Today is Tuesday, May 19th, 2026. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Marquise Hernandez, inmate number 432-663.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Mr. Hernandez.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make the recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hernandez, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. You can put your hand up. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
Okay. We're going to go over your rights. You have the right to be represented by an attorney at this hearing, and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are ready to go forward?
Yes, sir.
Okay. We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge number 1, condition of reporting, that on September 18, 2025, parole conducted an unannounced home visit at your only parole and community services approved address, which is in East Hartford. Your sponsor reported to parole that you were not there and were staying elsewhere, reportedly dog sitting. Parole contacted you and instructed you to report to the Hartford Parole Office on September 22nd, 2025. You failed to report as instructed on September 20. Second, 2025, your parole officer gave you further instructions to report to the parole on September 23rd, 2025. You again failed to report as instructed. You did not report to the parole until September 24th, 2025. Your behavior places you in a clear and direct violation of your signed parole conditions, specifically under release directions and under reporting as you were instructed to report. You were aware of this instruction given to you by your parole officer on 2 different occasions, and you failed to report as instructed. On charge number 2, condition of absconder, that on March 12th, 2026, at approximately 2:37 p.m., you exited your only parole community services approved address, the CPA Halfway House, 119-121 Washington Street, Hartford, without an authorization and failed to return. You immediately had your cell phone disconnected after absconding, therefore preventing parole from being able to reach you. Your parole officer made multiple attempts to to locate you through various other sources on March 12th, 2026, March 13th, 2026, March 16th, 2026, March 17th, 2026, March 18th, 2026, as well as in addition to 2 attempts to physically locate you in the community on March 19th, 2026. You failed to return back to CPA halfway house. You failed to report to the parole officer. You failed to try to contact your parole officer, and you failed to turn yourself in. Based on these behaviors, as well as in addition to packing all your belongings and exiting the halfway house and disconnecting your phone, all clearly demonstrate your intent to evade your parole supervision, therefore making you an absconder. Your whereabouts in the community are unknown at this time. Charge number 3, condition of halfway house placement. That on February 24th, 2026, you were terminated from your employer from February 24th, 2026. And until it was discovered on March 11th, 2026, that you were terminated, you continued to sign out of the halfway house to community passes to your employer, knowing you were no longer an employee. In total, you accumulated approximately 112 hours of unaccounted for time in the community. Based on your behavior, you are in clear and direct violation of your signed parole conditions. Specifically under your additional condition of halfway house placement, where it states, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. During the times you were signing out, it was under the assumption that you were going to work, therefore you did not have permission from anyone to be anywhere other than work. That on March 12th, 2026, at approximately 2:37 p.m., you exited your parole-approved residence, the CPA halfway house, without permission. This places you in clear and direct violation of your signed parole conditions, specifically under your additional condition of halfway house placement, where it states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. You did not have permission from anyone to exit the halfway house. The state has filed the following exhibits that have been marked for identification purposes. Exhibit A, PCS conditions signed on December 4th, 2023. Exhibit B, Hartford Police Report from February 11th, 2024, case number 24-003694. Exhibit C, offender misconduct for contact with minors without PO's permission on February 11th, 2024. Exhibit D, offender misconduct for not staying at his parole-approved residence, September 18th, 2025. Exhibit E, offender misconduct for failing to report as instructed on September 22nd, 2025 and September 23rd, 2025. Exhibit F, PCS conditions signed at CPA halfway house on January 21st, 2026. Exhibit G, halfway house agreement signed at CPA halfway house on January 21st, 2026. Exhibit H, CPA halfway house incident report for unaccountable time from February 24th, 2026 to March 11th, 2026. Exhibit I, CPA halfway house incident report for absconding on March 12th, 2026. Exhibit J, offender misconduct for unaccountable time, February 24th, 2026 to March 11th, 2026. Exhibit K, remand to custody. Exhibit L, notice of parole violation. Exhibit M, notice of parolee rights. Exhibit N, parole violation report. In addition, the state has filed an addendum to the parole violation report that states, in reference to the parole violation report submitted by P.O. Miller regarding Hernandez Marquez, inmate number 432663, the following applies. On April 6, 2026, the Board of Parole issued a warrant based on report declared Hernandez an absconder from special parole supervision. On April 7, 2026, the case was assigned to Parole Officer Pinto for investigation. On April 14, 2026, Hernandez was apprehended by Parole Fugitive Investigations Unit subsequent to Hernandez self-surrendering himself at his relative's home. A remand to custody order was lodged with the New Haven Correctional Center as approved by Parole Supervisor Demers. On April 14th, 2026, Hernandez was served his parole violation notice and parolee rights at New Haven Correctional Center. The signed notice of parolee violation, parolee rights, and remand to custody were scanned into evidence and case notes on April 15th, 2026. Attorney Sirica, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
I did,
And did you review this information?
yes.
The defense has filed the following exhibits, which are marked as follows. Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, support letter from Enrique Hernandez. Exhibit 3, support letter from Tamara Salvat. Exhibit 4, support letter from Lisandra Benitez. Exhibit 5, support letter from Dahlia Nugent. And Exhibit 6, support letter from Tarina Vega. Today we have no witnesses. Attorney Sirica, do you request that any witnesses be allowed to testify at this hearing? It is now the defense's opportunity to call any witnesses, present evidence, speak to any evidence submitted.
Yes. Marquise, you were paroled on September 12th of 2023, correct?
Yes, sir.
All right, and you're not remanded till April 14th of 2026?
Yes, sir.
Okay, this is your first parole violation, correct?
Yes, sir.
Okay, and that absconder warrant that was issued, you voluntarily turned yourself in to the police on February 14th of 2026, correct?
Yes, sir.
Okay, and while it appears you were off the grid for approximately a month, you didn't have any police contact, meaning no new arrests. The police contact you
No,
had
sir.
was when you turned yourself in, correct?
Yes, sir.
Okay, so you were released on September 12th of 2023, and the first violation I see here that's brought against you under reporting occurred on September 18th of 2025. So if my math is correct, it's approximately 2 years later since
Yes,
you were
sir.
out on supervision that this non-reporting occurred, correct?
Yes, sir.
Okay. You were given instructions to report on the 22nd, the 23rd, but you did eventually make it there a couple of days later on September 24th of 2025, correct?
Yes, sir.
Okay. And during this period of time when you were supposed to report on the 22nd, 23rd, and then you did make it there on the 24th, were you working at this time?
Yes, sir.
Okay. What type of work were you doing?
I'm a home health agent. So I was taking care of a patient in a PCA field.
Okay. And was your parole officer aware that you were working?
Yes, sir. Yes, sir. I made it aware, but she still wanted me to report, but I couldn't leave my patient by herself.
Okay. But eventually you did make it there on the 24th.
Yes, sir. That was my day off, my
Okay.
next day off. I made it there.
So here in the examiner Menard, we're not disputing you didn't report the day to parole. I just wanted to give you a little background via context of the type of work he did, and he did, not disputing he was late. He did make it there 2 days after he was
Okay.
paroled. I just want to make sure that
Okay.
that part of it is clear. Marquise, regarding charge number 2, absconder, you're not disputing you left the halfway house, correct?
No, sir.
Okay. Did you, without put specifics on the record, because it's in the narrative your parole officer wrote, did you have some safety concerns as to why, one
Yes,
of the
sir.
reasons why you left?
1,000%.
Okay. Were you a victim of a particular incident?
Yes, sir. After the incident.
Okay. And were you, as the victim, were you shot 5 times?
Yes, sir.
Okay. And you had some concerns regarding your safety, correct?
Yes, sir.
Okay. Now, in the violation, the language they use is that you left without authorization. You immediately had your cell phone disconnected after absconding, okay? That cell phone you had, was that cell phone under your name?
No, sir.
Did you pay the bill for that cell phone?
No, sir.
All right, so did you have access to disconnect your phone?
No, sir.
Okay, so was it under someone else's plan, I'm assuming, while
Yes,
it was
sir.
activated? Okay, so you did specifically yourself cancel the cell phone?
No, sir.
And just to clarify, charge number 3 under halfway house placement, where they discovered that your employment had been terminated. Were you working more than one job during that time frame?
So at that time, I was working for Cardinal Health and I still had my HHA job.
Okay. One of those employers where you were working at, were they aware that you had you were on GPS and you were living in a halfway house?
No, sir. They weren't aware because if they was aware, I would get terminated. So I kind of got into the job by sliding through the cracks.
Okay. And so during that time frame, you were still actually, I understand what parole wrote as far as your violation. It's your testimony, you were still working.
Yes, sir.
Okay. And which job was that where you're actually still working?
Robert Street.
Okay.
The Cardinal Health.
Okay. And they had no idea you weren't living in a halfway house? They
No,
had
sir.
no idea regarding your situation?
No, sir, not at all.
Okay. And then eventually, like I said, approximately a month later, you came to your senses and you knew there was a warrant out and you took it upon yourself to turn yourself in, correct?
Yes, sir.
I don't have anything else to add for the first part of the hearing. I just wanted to give you a little background as to what occurred. And regarding the comments I made regarding charge number 2, regarding his safety concerns, it is in the narrative. I think actually even on the addendum part, looks like the 4th paragraph, that there was an incident that occurred where he was the victim on an ongoing case, and it's apparently still an active criminal charge, not against my client.
Okay. Thank you. And anything further before I announce my
Regarding the
findings?
first part of the hearing, no.
I will now take a moment to review the case and will notify you of my findings in a minute. For charge number 1, I find that you violated the condition of reporting based on the evidence presented in State's Exhibits A, D, and N. For charge number 2, I find that you violated the condition of absconder based on the evidence presented in State's Exhibits A, N, I, F, and G. For charge number 3, I find that you violated condition of halfway house placement based on the evidence presented in State's Exhibits F, N, G, I, and K. That concludes the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity. There's no state, no parole officer here, so the purpose of this part of the revocation hearing is to help determine what outcome I will recommend. And Attorney Sirica, do you have anything that you wish to say?
Yes. On behalf of Mr. Hernandez, my client, he's 20 years old. He does have one child. As I've already indicated, my client was on parole from September 12th of 2023 and was not remanded until April of 2026. So he was out, my math is correct, about 2.5 years or so. This, as once already indicated, this is his first parole violation. Upon his release, he did successfully complete the Community Solutions Halfway House program in Hartford. And he was discharged to special parole. He was at the Chrysalis Center. And then he was sponsored by his grandmother in East Hartford. And then he was sponsored by his daughter's mother in Hartford. As far as his education, he did graduate from East Hartford High School. He did approximately obtain 7 credits from Three Rivers Community College in Environmental Health and Science in 2023. And he was due to begin an elevated construction program in Middletown, but he was placed in the CPA halfway house. As far as his employment, from 2024 to remand full-time as a home health aide, as he indicated, type of work he did, and he was working his other job. Full-time for Cardinal Health through Aerotech Staffing for approximately 4 months, and that job was to a temp agency. While he was at the Eileen O'Connor House, he did report he successfully completed anger management at CRT in Hartford. I already put on a record regarding his physical health as to what occurred. He did, as community service, he did assist his uncle, Mr. Bermudez, with a CPR course at their church. And he did successfully complete GPS monitoring, it looks like from January 21st to 26th to February 24th to 2026. And it's noted in the narrative that GPS monitoring unit was actually removed from his ankle there. Upon his reinstatement, he'd like to be placed with his sponsor, Ms. Benitez. I provided you the address and the phone number. If that doesn't work out, I just need to make a correction on that document we just submit. This first choice for halfway house will be New London. And the second choice is New Haven if the sponsor does not work out. He, at some point, would like to buy his own house. He has job opportunity waiting for him at the Greenwood Industries Commercial Roofing Company in Glastonbury, and he can also return to his home health aid position, and he's amenable to all treatment recommendation. I want to put on a record, I obviously read the document submitted by his parole officer, and the recommendation was 9 months. In my humble opinion, that's rather on the high side, given it's my client's first violation, given the amount of time he was out in the community, and given that I understand one of the charges was an absconder charge, where he did turn himself in on that. The other comment I want to make regarding, it's in the recommendation from Exhibit N, where it reads, student in hand is making the clear choice of absconding, packing his belongings, disconnecting his phone so no one can reach him. Is this parole officer's recommendation that he serve a period of 9 months for this violation? Hernandez also appears to have a concerning pattern of threats of violence. I'm not sure why that's listed in that recommendation, given the nature of the charges that are being brought against my clients here. There is no domestic incident, there is no assault, there's no incident at a halfway house. Why that language is in there, I can't speak for the parole officer, but it's not a fair statement, in my opinion, to be brought to this hearing, given the nature of this violation. But I just want to bring that to your attention, because I know the hearing examiners read the documents very carefully, like the attorneys do. I just want to bring that to your attention. We got reporting, we have an absconder at halfway house claim. There's nothing about any violence of the charges that were brought against him. The last thing I want to put on a record, we did provide you with 5 support letters. My client was out in the community for quite a bit of time. He does have an established support system in the community, so I don't need to read those letters. I know the hearing examiner can read. And he got his father wrote a letter. Miss Salvit, Miss Benitez, Nugent, and Ms. Vega. So those are support letters on behalf of my client. So he does have people in the community that do support him and stand by him. Mr. Marquis, anything I left out about your background or what you want to do when you get out? If you feel I left anything out, he has a copy of the report, but if there's anything you want to add.
So I have, for my background, I actually have goals that I would like to achieve, but I also have in play for whatever decision you do decide to give me, that I would like to get rolling in motion from running my own business and doing things for the community as well.
Okay, thank you for your comments.
And just one thing to clarify, you said the halfway house, it's the Norwich region, so not New London, but I believe New London falls within that Norwich region for a halfway house, okay?
Yes, sir.
All right, anything else? I don't have anything else to add. Thank you for clarifying that.
All right, I'm just going to take a moment before I make my recommendation. I've listened to testimony and reviewed all the evidence provided. Based on that, I recommend that your special parole be revoked with a new re-parole date of October 14th, 2026. This is an approximate 6-month sanction. This sanction is calculated from the date you were remanded to custody. The following conditions are recommended for your special parole release. Halfway house placement, general no contact with minors without parole officer's permission, no contact with TS and LH without parole officer's permission, behavioral management, anger management, no contact with victims, RG, and mental health treatment. My findings and recommendations will be forwarded to the board on June 4th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with a written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you'll have an opportunity to respond to those specific reasons while in front of a panel of the board. This concludes the revocation hearing, and I'm now going off the record.
So Marquise, it's going to the board for review on June 4th. You and I will get something within a week to 10 days. If they adopt the recommendation, your release date will be October 14th. If for some reason they reject it, there's another hearing. I'll set up a call with you, but hopefully that's okay.
Okay.
All right, good luck to you.
Oh. Right.
Yeah, you probably gonna have to turn on the volume too. Sometimes it don't be on.
It'll be.
Invite to meeting.
Hi, officer. If you just want to switch the tablet to presenter view, and then you can minimize the chat.
Oh, okay. Yeah. All right. Next. We're good?
No, look. Gotta put it on the big screen. It says right there.
Yeah.
So on your TV, do you see
Yeah.
on the TV itself, not the tablet, do you see the video thumbnails on the left-hand side of the screen?
No.
On the tablet, it should say
Yeah.
you're in attendee view, switch to presenter view.
Yes, I'm
So
pressing
you
it.
press switch to presenter view, and what changes is on the television.
Yeah, so it's say you are in presenter view.
Okay. And
It's
then
saying
there's a
that we
little
are.
chat bubble that has a blue line underneath it, and if you press that once,
Yep.
the blue line would go away and it just minimizes off the screen.
Okay, that's what I just did.
Yep, and then you should be all set.
Still saying state of Connecticut. Honestly.
Yep, you should still see the logo.
Okay. So we should be good.
I guess. Can you see me?
You can see her?
Yep, and you'll be able to see everybody in a moment when the officer gets started.
I can see everyone now.
So we can see you guys. Could you see her?
Yes,
Okay, so we're all set?
yes.
Okay. All righty.
Good morning. I'm Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Lakeisha Campbell, inmate number 251496. Today is Tuesday, May 19th, 2026. This is a hearing being conducted via video at the BOPP Central Office in your correctional institution. Can you please state your full name and DOC inmate number for the record?
Lashika Campbell, 251496.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean and P.O. Richardson. Can you please identify yourselves for the record?
Yes, Hannah Dean on behalf of Ms. Campbell.
Officer Richardson, Mental Health Unit Parole for Hartford District.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, better or weightier evidence must establish that more probably than not an allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make the recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Ms. Campbell and P.O. Richardson, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes.
Thank you. So we're going to go over the procedure of the hearing. First, I will read you your rights. Then we will review the parole violation charges the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After the considering of all evidence presented, I will announce my findings. If I find that you violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you'll have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, sir.
The rights of the parolee rights. You have the right to be represented by an attorney at this hearing and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, sir.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, sir.
Okay. We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Richardson, you go ahead.
Okay. Charge number 1, obedience to the law. On 1/16/26, while at the Department of Social Services building in Windsor, you became agitated and began screaming, causing alarm inside the building. Due to your behavior, a Connecticut State Trooper assigned to that building instructed you to leave. You refused to follow his direction. When this trooper attempted to escort you out of the building, you dropped yourself to the floor as dead weight. While you continued to be escorted out of the building, you kicked the trooper in the left knee. Due to your uncooperative and combative behavior, the assistance of additional troopers and officers from the Windsor Police Department were required to detain and transport you to the Connecticut State Police Troop H. During processing at Troop H, you continued to be uncooperative and refused to sign all processing paperwork. Based on your actions, you were arrested and subsequently charged with CGS 53A-167A, interfering with an officer and resisting, CGS 53A-167C, assault on a police officer, 53A-182, disorderly conduct, and CGS 23-12, failure to fingerprint. On 1/20/26, you were arraigned at GA 14 Hartford, where probable cause was met. You were held on a $15,000 bond and given a next court date of 2/20/26.
Thank you. The state has filed the following exhibits that have been marked for identification purposes. Can you please read those?
Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, State of Connecticut Department of Emergency Services and Public Protection Investigation Report. Exhibit F, State of Connecticut Judicial Branch pending case detail. Exhibit G, Board of Pardons and Parole Decision Information Summary. Exhibit H, Board of Pardons and Parole Revocation Summaries.
And can you please read the addendum? Or
No,
did
I
you already
apologize. I do not have the addendum in front of me. I just have the original paperwork.
Okay. I'll read the addendum if you don't have it.
Thank you.
Addendum number 1 on 4/21, on April 9th, 2026, Ms. Campbell was seen at GA 14 Hartford under docket number H14H-CR-26-0775410-S. The charges of interfering with an officer, assault on a public safety officer, disorderly conduct, and failure to comply with fingerprints were nollied. On March 27th, 2026, while awaiting her revocation hearing, Ms. Campbell received a disciplinary report for disobeying a direct order. Please see additional parole violation report evidence. Attorney Dean, did you receive the notice of parole violation report and the other documents I just marked for identification purposes?
Yes, we have. Thank you.
And did you review this information?
Yes, thank you.
The defense has filed the following exhibits, which are marked as follows. Exhibit 1, list of parole accomplishments and future plans for parole, and Exhibit 2, video evidence. Today we have no witnesses. Attorney Dean, did you request any witnesses to be allowed to testify at this hearing?
No, we did not. Thank you.
Okay. At this time, the state will have an opportunity to call in witnesses, present evidence, and speak to any evidence submitted. This is your opportunity, P.L. Richardson.
Yeah, nothing to say in regards to the charges themselves.
It is now the defense's opportunity to call any witnesses, present evidence, and to speak on any evidence submitted.
Yes, thank you very much. As to the charge, I would argue that there should be a no finding. First, all the charges were nollied in court. There were no convictions in the case. This was a situation where my client was offered an unconditional discharge on her first court date. And if she had accepted, she could have potentially gone to her revocation hearing rather quickly with the chance to get out potentially sooner. However, she was adamant from the beginning that these allegations were incorrect and insisted that her attorney get the body-worn camera video for this case, even if it meant her having to remain incarcerated for a longer period to fight the case. That video was eventually obtained, and my understanding is that the prosecutor viewed that video along with defense counsel, and upon observing what had occurred there, determined the appropriate action was to nolly the case. I would argue nothing in the video rises to the level of the criminal charges for Ms. Campbell. I did include that as evidence, and I don't want to belabor what was depicted there, but there are just a couple of brief things I wanted to highlight. First, my client was approached by numerous male officers after she had entered the women's restroom and was accused of being a male using a female's restroom. In discussing this with the officers, my client was understandably annoyed, but at no point was she aggressive. And at no point when she exchanged words with the trooper do you see spit or anything of that nature coming from her mouth, which is what is later alleged in the police report. From my view of the video, it appears to me that the police personnel, did escalate the situation by grabbing my client in an aggressive manner to take her out of the building. From reviewing the video, it does look like at that point she trips and falls to the ground. They allege that in dragging her out of the building, she had kicked an officer's knee. But I will note that my client on the body-worn camera repeatedly tells the officers that she was flailing her legs in an attempt to regain balance, and that in no way did she intentionally kick that individual, and that was a complete accident. Upon this happening, the officer on scene, by my understanding, punched my client in the face, which he flippantly acknowledges on the video, saying something to the effect of, "You're damn right I did," when she expressed concern over this, which, I believe was very inappropriate. I do think it's worth noting that throughout these interactions, the police continued to misgender my client as well and referred to her as a male throughout the interaction, which, I think just on a personal level is very, offensive and degrading. I understand that the burden of proof is different in parole versus in criminal court, but I would argue that based upon these facts, the evidence, and in the interest of justice, that there should be a no finding for the charge. Thank you.
Can I just respond
Go ahead.
briefly? Yes, I just want to put on record that at the time that our parole violation report was written, all we had access to was the police report. We had no knowledge of any body-worn camera, nor did we have access to that. And so obviously that was brought to our attention yesterday when Attorney Dean reached out to us. So obviously we just had to go by, the police report, which was provided to us by TrueBH at the time of the violation. We would also note that the charges were nollied and not a conviction of not guilty. We would also like to note that for the record as well when the findings are considered.
Okay. Attorney Dean, do you have anything else you'd like to say?
No, I would just note for the record that Officer Richardson was very helpful and cooperative in me, reaching out to her concerning the video evidence. And, defense understands what she's putting on the record, that at the time when the violation was written up, they only had, a certain amount of evidence available to them. Thank you.
And you have anything else to say, P.O. Richardson, or is that?
No, that was it. Thank you so much.
I will now take a moment to review the case and will notify you of my findings in a moment. Okay. On charge number 1, condition of obedience to the law, I make a no finding. Your parole will be reinstated. The records office at your facility, as well as your parole officer, will be notified. And this concludes the revocation hearing. I am now going off the record.
Ms. Campbell, you'll be getting released. She's special or discretionary? Special parole. So you should be getting released by the end of the day today, Ms. Campbell. I know that your officer has been working to get a halfway house and everything set up in the event that you were released today.
We have a bed all set for you, Campbell. So we're gonna.
I can't go back to a reach bed?
So there isn't a reach bed available because those fill up so fast. So in the event that we needed to place you like emergently, like today, we were kind of working behind the scenes. I didn't want you to have to wait around too long. So we have a halfway house bed ready for you to go. We have an officer ready to come get you.
May I know where I'm going?
So I haven't heard that yet because I don't get to pick the bed. I just have to make a phone call and say, yep, she's coming out. And then
So
they'll tell me.
They'll let you know as soon as they pick you up, and just like last time, just work with the personnel in the halfway house and your officer. for the reach, and that, you know, certainly is something that they can discuss with you going forward. But as for the purposes of today, they had to have somewhere for you to go in the event that this happened. So she already has the halfway house set up for the time being, okay?
Yeah, you still have a little bit of time left, so you can still get to a reach bed. That's not completely off the table. It's just we want to get you a bed for today. Bennick is a little bit closer to you than I am, so she's going to be coming to pick you up, okay?
Okay, thank you very much.
You're welcome. We'll see you soon.
Okay.
Thank you,
Thank you,
everybody.
everyone.
Thank you.
Hello, officer.
How are you? Are you looking for Cologne?
Yes.
He actually went to Yukon Hospital this morning. They wanted me to let you guys know that.
Okay, we're still gonna state something on the record, so we'll just keep the video up for a sec, okay?
You need me here for that?
Nope,
Okay, so
we'll be done in 2 minutes.
Yep, no worries. Thank you.
Good morning. This is regarding inmate Jose Colon, inmate number 244171. We're just told by correctional officer at Bridgeport CC that Mr. Colon is currently at the hospital. Attorney Matthews, would you like to continue this hearing?
Yes, I'd ask for a continuance of the preliminary hearing until, I believe, next year, June 2nd.
Okay. All right, so I'm going to accept that continuance for June 2nd. And that concludes the hearing. Thank you. Did you get that, McNeil?
Yes,
June 2nd? All right.
Yep.
Thank you.
thank you.